and you've now picked up an assault case. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause.
On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This is an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the summary.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, Judge, it's in the...
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received
it looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she, I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was ordered by the magistrate.
I wasn't aware of that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that, yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may.
Yeah.
Your Honor, she just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, 2 at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
Judge, there was a conflict, that's why the BVR was submitted. So the magistrate ordered bond conditions, but the curfew times were not aligning with the felony conditions.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the whole up right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions.
And Your Honor,
she received conditions of bond on April 28, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge, and on the felony conditions, I'm looking at them right now. Her curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate ordered from 7 p.m. to 7 a.m. and on felony, their curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but you abide by the conditions and then you come to court and you ask to, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Your Honor, if I may again.
Sure.
This is a brand new case. Could the court admonish her? Because the amount of time, I understand that.
Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew. and she's just doing whatever the hell she wants to do.
This hearing goes off the rails immediately. The judge is not just looking at a simple assault allegation here. He's looking at someone already out on bond for a murder case. In bond court, that changes everything. The second a defendant is accused of violating conditions, especially with a new arrest attached, the court starts treating it like a public safety issue instead of an isolated incident. And you can already hear the frustration building.
All right.
The judge. Judge on.
We're doing here. There's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case.
Judge, on April 23rd, 2025, an officer dispatched an assault call and made contact with the complaining witness, and the defendant. The complaining witness stated that he saw the defendant talking to and following a witness, and the witness then started to run away and observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain and then grabbed the defendant, and they proceeded to grapple until security arrived. The witness stated that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone, and the defendant continued to refuse to do so, and that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Then corroborated the facts that the complaining witness provided about getting in between the two of them.
Mr. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession of weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand?
Yeah.
Don't be a danger to my city, man. I'm not asking for much.
I'm not in danger. I do never know these people, Your Honor. I was out. I need a public defender.
I'm gonna give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never in danger. Just I don't intend to be in danger either.
All I want my streets safe.
They was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs. You
Can
understand?
you protect me from these kind of people?
I'm going to have you go to Victoria, sign a reset. After that, I'm
I
going
do
to
need a public defending office, your judge or
I already
lawyer.
told you I was going to give you one. Just really.
I'm really scared for my life because I just did 4 years and I'm going through the same thing again in your courtroom when I did good and I'm going through all the facilities. There was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there.
No. Exercise.
And I'm running from these people.
You're going to say something that hurts your case. Just stop.
Yes, sir.
I'm not asking you to say anything. I just want
to also be safe in your community also.
Don't use any dope. Don't use any alcohol.
Never was. I was sober that day. I was sober as can be. No drugs, nothing. Enjoying a beautiful day for my mama's funeral. I know no news. I don't know these people.
Listen, I'm going to have you sign a reset. I'm going to have you take your seat in the jury. Yo, I'm not talking to you. Once you sign the reset, just take a seat in the jury box. I'm going to find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions.
Now this is where things get legally messy. The defense is arguing the curfew orders conflicted with each other. One order said one thing, another said something completely different. That may sound technical, but in court, technical mistakes can become huge problems. The judge, though, is focused on one question. Why didn't you come back and fix the order instead of just ignoring it? Fair or not, judges hate when defendants make their own interpretation of bond conditions.
Little mischief. You've now picked up a new case. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On April 26, 2025, a law enforcement officer is on patrol and observed a motor vehicle run a red light and make a U-turn, nearly striking another vehicle in Harris County, Texas. Law enforcement officer observed the motor vehicle drive onto the curb of Richmond Avenue and initiated a traffic stop. The defendant passed multiple open parking lots and continued to drive. The defendant eventually pulled into a business parking lot. A law enforcement officer contacted the defendant and observed him to be eating fried chicken. The law enforcement officer asked the defendant why he didn't lower the window, and the defendant stated he didn't have any and continued to eat. The law enforcement officer observed the defendant did not have a driver's license and was incoherent when asked to provide his name and date of birth. Law enforcement eventually identified the defendant by name and date of birth. The defendant continued to state, "I don't have anything unquestioned about his whereabouts," and standardized field sobriety tests were conducted. The officer observed 2 out of 6 clues in the HGN, 5 out of 8 on the walk and turn, and 0 out of 4 on the one-leg stand. Due to the defendant, 0 out of 4 on the one-leg stand due to the defendant being unable to perform the test. The law enforcement officer noted that on the walk and turn, the defendant did not turn around. He stayed still for approximately 30 seconds. The law enforcement officer explained the one-leg stand, and after the instructions, the defendant began performing the walk and turn. This occurrence happened again after the law enforcement officer tried to explain the one-leg stand another time. The law enforcement officer observed 2 unopened 6-packs of alcoholic beverages that were cold to the touch, and observed an empty fuzzball and a 24-ounce can of Modelo beer and an empty Twisted Tea alcoholic beverage. The defendant refused both breath and blood. A blood warrant was signed and executed.
Mr. Juarez, I'm going to find that there's enough probable cause to go forward with your case. You said he doesn't have a license, right?
There's a number here. I'm not unsure if that meant that he did not have a license at the time.
I have mind running it, please.
Yes, Judge. Your Honor, he does have an eligible driver's license.
I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I've ordered you not to pick up any new cases, not to violate conditions of bond, and you have repeatedly done that. As a result, I am now revoking your bond on the first case, and you will go to jail today. And I'm going to tell you, you violate conditions again, I'm going to make the bond so high your head will be spinning. Do you understand? You are not to consume alcohol or illegal drugs, and I will put a scram on your ankle so I know that you're not consuming. Do you understand?
Your Honor, if I may,
Yes, sir.
on the first case, the court previously was testing Mr. Juarez 2 times a week, and he was doing pretty good on that for an extended period of time. In lieu of revoking his bond, would the court consider going back to bi-weekly testing?
No. He picked up a serious case. He has alcohol in the car. I mean, he's allegedly consuming while he's driving, you know? I would figure that it's damn elementary that you're not to have alcohol in the car while you are driving. And there are multiple open containers, cold to the touch. No, I have to show you that we mean business. And me letting you go again when you have multiple violations, it's not going to happen. You go to jail. I don't know what we're going to do when he bonds out, Michael, as far as testing now. I don't know. But
I understand, Judge.
I'm going to order him not to drive as well. I mean, he's got alcohol. No, it's not going to happen. Good morning.
Judge, I'm approaching on Victor Jesus Rauda Lopez, and he's got a bond violation reported on him.
Page 10.
Is he here?
He's here, Judge. He's in the jury box.
Speak English?
Yes, he does.
Come up. Come up.
Answer yes or no, sir.
Did you get your GPS device?
Oh, yeah.
Notice how this judge keeps repeating the phrase, my city. That's not accidental. He's framing every case around community safety, not just individual guilt or innocence. And for viewers watching this unfold, here's the big question. When someone is emotionally unstable or scared, should the court focus more on punishment or intervention before things escalate further?
Fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. It looks like you're also charged with unlawful carrying of a weapon. On that one, you're facing up to a year and or a $4,000 fine. Okay.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling 50 miles per hour in a 30 mile per hour zone via radar and failed to signal at a right turn. A traffic stop was initiated, and upon contact with the defendant, the law enforcement officer observed a handgun on the rear right passenger floorboard, unholstered and later confirmed to be loaded. Law enforcement officer observed glossy eyes, strong odor of alcoholic beverage, and slurred speech from the defendant. The defendant admitted to consuming 3 alcoholic beverages. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 2 out of 4 on the one-leg stand. The defendant consented to provide breath and blew a .136 and a .141.
Okay. Any prior DWIs?
Yes, Your Honor, out of a different county.
Is it open?
No, Your Honor, it was closed in 2014 with 12 months of probation.
Can you run a full NCIC to see how many there are?
Yes, Judge.
Mr. Ayler, I'm going to find that there's sufficient probable cause to go forward with the case. Also, if you can run his license, please. I'm now placing a restriction on you, Mr. Ayler. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. No more PR bonds. Likewise, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. I'm sending notice to DPS in Austin. Every single officer in the state will know that if you're driving a vehicle and it doesn't have an interlock, you will be arrested and put into jail. Do you understand?
Judge, it's just the one previous DWI.
Okay, license, what'd you say?
License.
You're also not allowed to drive unless you have a valid license and liability insurance in your name as well. That is a part of your bond conditions. For now, I'm going to have you go to Victoria, sign a reset. You will eventually get with Roxanne for your bond conditions, and after that, you'll be free to go.
It is eligible.
Great. Okay, come on. Mr. Bustamante, I know that there are 2 sides to the story. I get it, right? That's why we have trials. But in the interim, we ask you to do several things. And when you don't, there are serious consequences. Number 1, we ask you to show up. On your first case, you failed to appear just in and of itself, and we had to issue a warrant for your failure. We issued bond conditions on that as well. Those conditions were also broken. You've now picked up a new case. I want you to understand something and listen and hear me clearly. Mr. Bustamante, I want you to listen and I want you to hear me clearly, because what I'm doing now is I'm putting orders of protection on both of your cases. And if you violate these, you are looking at 2 more very serious violation of a protective order case. That in and of itself is the capital murder of misdemeanors. Do you understand? You violate conditions on that, I can have a hearing to hold you at no bond.
I understand 100%, sir, Your Honor.
The only thing I am asking you to do is do not have contact with either of the complaining witnesses in these cases. I don't care if they're relation. I don't care if there's no relation. I don't care who they are. Do not have contact. And when I mean no contact, I mean no contact of any kind. No phone calls, text messages, social media, emails, Snapchat, whatever, maybe smoke signals. No means no.
No problem, Your Honor. It's not a problem.
So this is now an order that identifies both Bustamantes as protected individuals. You cannot communicate with them. You cannot commit an assault.
That line right there, "I'm revoking your bond," is basically the courtroom equivalent of hitting the emergency brake. The judge is signaling that repeated violations wipe out whatever trust the court originally gave the defendant. And honestly, the details make this worse. Open containers, alleged drinking while driving, prior bond conditions already in place. This was probably heading toward revocation the second the case summary started.
Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, communicate with a third party to try to communicate with them. You cannot be in possession of a weapon or go within 200 feet of where they live or where they work.
I understand, Your Honor. I got 7 kids, and those are not the oldest ones. I'm a good daddy.
Don't talk to these two.
I understand, Your Honor.
This order only applies to these two. Don't use the other kids to try to have contact with these. If you do,
We all live together. Right.
now you don't.
Right. I'll go to mom's house.
Best go somewhere else because they're going to inform those kids now that you're not supposed to be there or have contact with them.
That's not a problem, Your Honor.
All right.
The first one, my daughter, she doesn't live here. She ran away with her husband. Whenever she called the cops, she wasn't even at the house.
I don't.
Understand?
Don't go into
You
the
have
fact-
contact with them. I'm not asking you much. You've already picked up 2 cases. You pick up a third, I'm going to blow a gasket.
That's done. You got it.
State, is there anything else?
Yes, Your Honor. There are allegations of drug use too. We would ask for reading your analysis.
Okay. You're not to use alcohol, illegal drugs. I'm going to randomly test you. If I find that you're using, likewise, I'm going to revoke these bonds and we'll put you back in. As it stands now, you are a flight risk. I'm not going to give you a PR bond. So what'll happen now is we're going to put you back. I've got your bond set. If you have someone that posts your bond, then you must abide by these conditions.
My daughter, my daughter.
I've given you a lawyer. You need to talk to the lawyer. You have the right to remain silent. Everything you say, they're going to sit there and they're going to type it to use it to prove your guilt. Just don't say anything. I'm telling you what the expectation is. So if you do get out, you don't pick up a third case.
I have a question.
What's the question?
Ask
Actually,
the lawyer.
Okay, so, okay.
Okay.
we're good, Judge.
You good? Okay. All right, Mr. Bustamante, you know what's expected of you from now on. That's it.
Thank you, Your
Okay.
Honor.
So we need him to sign conditions
Yes,
with
sir.
Roxanne whenever she's ready.
You come up here so I can.
I'm not equivalent. I want to go.
Please.
I don't want to go to jail.
Good morning, Mr. Godine.
You doing, sir?
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Thank you, Your Honor. On April 26, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle run a red light and initiated a traffic stop. The law enforcement officer made contact with the defendant, the driver, and observed bloodshot eyes, droopy eyelids, constricted pupils, unbalanced, and the defendant to be talkative and have trouble concentrating. The defendant admitted to running the red light. Standard field sobriety tests were conducted. A 2 out of 6 was reported on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The defendant estimated 30 seconds passing and what was in reality 72 seconds on the one leg stand. The defendant admitted to smoking weed earlier. The defendant consented to breath and blew a .00. The defendant consented to drug influence evaluation, and a drug recognition expert believed the defendant to be under the influence of a central nervous system stimulant, a narcotic, an analgesic, and cannabis. Thank you, Your Honor. And the defendant admitted he took oxycodone or narcos and smoked weed. A blood warrant was obtained and executed.
Mr. Godin, I'm going to find that there's sufficient probable cause to go forward to the case. If you have a drug or alcohol problem, now is the time for you to address it. I'm giving you the opportunity now. If I find it becomes a problem while you're on bond, I'm going to revoke your bond. I will put you in jail, and I'm going to address it myself. Oxy is one of the absolute worst things that you could possibly take because you build up such a tolerance to it.
Capital murder of misdemeanors. That's a dramatic phrase, but the judge is trying to emphasize how seriously courts take violations of protective orders. Once no contact orders are in place, even a text message, a social media DM, or using another person to communicate can trigger entirely new criminal charges. And you can tell the judge is trying to leave absolutely zero gray area here.
You literally put your lungs to sleep if you take too much and you end up dying. I cannot tell you how many people have died from this drug. It's absolutely disgusting. And the maker has been sued repeatedly by how many different states in this country because it's such an addictive thing. Don't use. I'm telling you now, within the next week, I'm going to test you because I want to make sure you're not using. Do you understand?
Sir.
Don't use. You've got a great lawyer here. She will take care of you, but I don't care who you have here. Jesus, you use. It's not going to go well. Do you understand?
Yes, sir.
License, prior DWIs?
The license is eligible.
Okay.
And not seeing any prior DWIs here, Your Honor.
I'm telling you that I've had probably a handful of friends that have died from Oxy because they continue to take it, build up that tolerance, and put their lungs to sleep. It's disgusting. Just don't. Do you understand?
Yes, sir.
I don't want you to kill yourself. Life is way too short.
Yes, sir.
You're not allowed to drive unless you also have a valid Texas driver license and liability insurance. Do you understand?
Sir.
Because you have a lawyer, we will waive your appearance, but it is your responsibility to stay in touch with Ms. Barks, and she'll tell you if and when you have to come back to court. Be careful. Don't use. As long as you do, all is well. Come on. Louisiana for a larceny. It's a misdemeanor. Am I right?
Yes, Your Honor.
Okay. Your lawyer's asking for me to set you a bond. I don't know. I need to know more about you. My primary concern, number one, are you going to go back to Louisiana if we give you a bond? Number two, are you going to leave a wake of destruction? Because that's what we don't want. We don't want you to be danger if you're danger. You know, well, I know that you're going to tell me it's little bunnies jumping in the woods. Everybody does, right? But how you look on paper really tells me who you are.
Your Honor, the demanding jurisdiction requested no bond because the demanding jurisdiction showed that she is also wanted for failure to appear for a DWI, and the FTA was issued out from Caddo Parish on July 21st, 2022, but then she picked up this larceny within the last couple of months this year. While that was an FTA, state requests that there's sufficient bail be set for the fugitive to be returned to the demanding jurisdiction. State requests a $10,000 bond because of the fact that it's a 3-year-old FTA. On top,
The case is 3 years old.
no. The
DWI.
pending, right? She also is wanted for a DWI out of the same parish, but this specific fugitive case is for the larceny. I'm just highlighting the reasons for the higher bail. It's because the older case was 3 years
See what I mean? That's what I'm saying. You know, yeah, I know what you're going to tell me, but paper tells me another thing, and that's a big problem. The DWI has been open for 3 years. Now, the only reason we have you is so are you okay with the bond then?
Okay, with a bond, just a sufficient bond that she return herself, Your Honor.
Okay.
Yes, sir.
Judge, we wouldn't be opposed to 10,000 if you could set it at that.
Okay. I want you to understand that I don't play games.
Yes, sir.
I'm not going to do this repeatedly.
Yes, sir.
I can set you a bond now, but if you don't go, I'm going to revoke this bond. I will set it at 0. And this time I'm going to hold you until Louisiana comes and gets you. And we're not going to do this again. You have one chance to make it right. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. You must turn yourself in. Not, I'm going to go do this. I'm going to hire a lawyer. I'm going to try to get a bond. No.
Just go turn myself.
Go turn yourself in. The other thing I'm going to tell you is that Murphy's Law, you know, what can happen will happen. Don't wait until the last day. You know what? I'm going to go turn myself in now. I don't care if you car trouble, abducted by aliens. Don't matter. As soon as you get out, I would go because that's a lot of money that someone else is toning up for you to get out. Do you understand? All right.
So I just wanted to highlight, and obviously the court set the bond. I'm not disputing that, but just because there have been 2 other fugitives from Caddo Parish that have waived, and I have 6 total from Louisiana. I imagine the transport is going to be soon. So regarding financial capabilities on storing the bond when returned to Louisiana.
So let them know, what he's trying to.
This moment shifts from courtroom procedure into something almost personal. The judge stops talking like a judge and starts talking like someone who's watched addiction destroy lives up close. Whether viewers agree with his approach or not, you can hear the emotional fatigue in his voice. And that raises another interesting debate. Do these bond hearings actually help people confront substance abuse, or are they mostly designed to control behavior until trial?
Tell you basically is that because Louisiana, we have so many people in our jails from Louisiana. We have buses coming 1 to 2 times a week to shuffle in people from and to Louisiana. So if you were to waive within the next couple days, they'll probably have you back in Louisiana, as opposed to someone dropping 10,000. You said 10,000?
Marcus Taylor?
So yes.
As opposed to someone dropping 10,000 to get you out to go turn yourself in within the next 2 weeks. It's up to you. I'm just letting you know what it is, and then you guys can decide what you want to do. Has she waived already?
She's waived. That's why I can stand down if you want to talk to her.
Once, because you have already waived, so we give them a certain amount of time to come pick you up. If they don't come get you within that time, we release you. Once, if you want to post bond, you have to withdraw that waiver, and you lose all the time that you've accrued toward that. I'll let it explain to you, and then you guys tell me what you want to do.
This judge. Okay. All right. And Judge, I guess we need to have Bushnell and DeRoyan brought out as well for their pre-signed waivers.
Just enter in the pre-signed waivers. Unless you don't want them to come out to enter, then
I don't care. Just have them sign it and get it. Yeah.
Well, they don't really need to sign, pre-signed.
Just explain to them if they have a problem, or if they don't believe you, or they're giving you a hard time, just let me know.
Okay, thank you, Judge.
Good morning, Mr. Garza.
Good morning.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, an undercover law enforcement officer observed a vehicle conducting multiple donuts in a parking lot in close proximity to other vehicles and pedestrians. The law enforcement officer maintained visual of the vehicle until another law enforcement officer was able to conduct a traffic stop of the vehicle and detain the defendant. The defendant admitted he was the one driving the vehicle and doing donuts.
Mr. Garza, I'm going to find that there's probable cause to go forward with the case. Does he have a license?
It is eligible, Your Honor.
Okay, I'm ordering you now as a condition of your bond not to participate in these types of activities anymore. Racing, street takeovers, donuts, reckless driving. If I find that you do, first I'm going to put you in jail. The next thing I will take your ability to drive away. Do you understand?
Yes, sir.
How old are you, sir?
17.
You want a court-appointed lawyer?
So what's up?
You need a lawyer to represent. Do you know if your family's going to hire you one, or do you want to apply? Okay, so you don't want to apply for a court-appointed lawyer. Okay. I'm going to have you go to Victoria, sign and reset. We'll have you take a seat in the jury box while I get your bond conditions. Don't drive maniacally. Do you understand? You are also not allowed to drive unless you have car insurance in your name as well. If I find that you're doing without it, it's not going to go well.
Yes, sir.
Come on.